Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the immigration, medical malpractice, and business litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. From case management systems to AI note-takers, law firms have more access to technology now than ever. Growing in 2026 requires finding that sweet spot where you're getting the most out of your tools and your team. On March 26th, leaders from e-Immigration and Staffy are hosting a free webinar on finding the balance between tech and talent. They'll cover what to automate and what to delegate, and how to grow your firm without overwhelming your people. It's practical, it's free, and it's built for immigration professionals. Register at eimmigration.com/events or click on the link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hi, everybody. Big week of cases, pretty long, so I'll try to be short up at the top. First, DPS is on fire this week, with the Solicitor General urging the Supreme Court to take our Haiti case, and the Ninth Circuit narrowly avoiding en banc rehearing on the Venezuela and partial Haiti case, with vigorous concurrences and dissents clearly directed towards the Supreme Court, if not one another too. The lives of like 1 million human beings hang in the balance, and something big's probably going to happen soon. Also at the Ninth Circuit, the Rosa Espinoza et al. Bondi saga appears to have resolved this week. Recall that weird decision about the Ninth Circuit's stay of removal practice in immigration cases? Ended with a bit of a dud, with the en banc court vacating the panel's opinion, but also denying the non-citizen's motion for a longer stay, and saying essentially that the panel went rogue, but that the Ninth Circuit will deal with its stay policies internally. Then the Chief Judge and Judge Chung went back and forth a bit. Weird case. None of it particularly normal for courts, but all of that appears to be a byproduct of the panel going a bit rogue at the onset. Wait and see, I guess, what happens with the Ninth Circuit's temporary stay policies in immigration cases, but it seems that the Rojas Espinoza family will now not be in America while their petition for review plays out. I'm glad we could put that to rest over many podcast episodes. Once I started summarizing and I just couldn't help myself. Anyway, this week, 8 cases. And if you think that's too much, blame the BIA for its 4. Although one of them was last week from the AAO. Whatever, I'm done with the qualifiers, let's get into it, let's rock and roll. See you at the end. Starting off with Sufiyan v. Bondi, published by the Second Circuit on March 12, 2026. This case is about asylum and other things like the material support of terrorism. Judge Sullivan concurred in part and dissented in part. It's a Sri Lankan case, and the immigration judge denied asylum, concluding that Mr. Sufiyan provided material support to the Liberation Tigers of Tamil Eelam, the LTTE, which is a designated foreign terrorist organization. Not sure if they're still around or not, but still a terrorist organization, I guess. And the whole thing gets complicated. Here's why. In 2009, Mr. Sufiyan was stopped by LTTE members in Sri Lanka while driving with his boss. The LTTE members flat out stole the car with Mr. Sufiyan and his boss in the vehicle, drove them to a wooded area, and then shot the boss twice in the leg. Then they detained Mr. Sufiyan and his roommate in a nearby home, unsure where the roommate's coming from in this story, and made Mr. Sufiyan translate for them as they beat and interrogated the roommate. Seems like Mr. Sufiyan was fluent in Tamil, which I imagine the LTTE members speak, and Sinhala, which I imagine is what the roommate speaks. Quote, given that they had shot his boss, he thought they would kill him if he did not translate as requested, end quote. A not crazy thing to think. What is crazy is that likely qualifies as the material support of terrorism under U.S. law. By the way, he was then beaten by the Sri Lankan army and detained for months when, being transported with the LTTE members later, they thought he too was LTTE. He was only allowed to leave because his brother-in-law stepped in months later, and the officers said that they'd kill him if they ever saw him again. He got to America through a seaman's visa and applied for asylum. Granted, he applied after over a year coming here, and after 3.5 years living in what appears to be safety in another part of Sri Lanka. Quote, for several overlapping reasons, the IJ denied all relief and ordered Mr. Sufiyan removed to Sri Lanka, end quote. But one of the reasons for asylum and withholding of removal was the material support of terrorism bar. No duress exception there, reasoned the IJ, relying on the BIA's precedent, surely. Seems like the IJ denied the claims on the merits, too, as the IJ denied cat protection. The BIA affirmed, but didn't get into the substance of the immigration judge's asylum or withholding of removal denial, or if the IJ erred. The BIA affirmed on material support, and deemed that issue dispositive, which, if correct, it is. Convention Against Torture Deferral was denied on the merits by the BIA. But here's the thing. Before the BIA and now the Second Circuit, Mr. Sufiyan argued that the immigration judge and then the BIA erred in failing to decide, quote, whether he would be eligible for relief but for the material support bar, end quote. Because if the BIA had, Mr. Sufiyan explains, our crazy, disjointed immigration system would allow him to navigate the labyrinth of then seeking a waiver with USCIS, a waiver that, if granted, could then result in Mr. Sufiyan getting asylum or withholding of removal. I guess after reopening? More on that later in the case. Also a tad confusing to me, as it does seem that the IJ denied asylum based on a 1-year bar finding and maybe some other reasons, and got into the merits of withholding of removal. But the main focus is the BIA's decision, which only affirmed denial of asylum and withholding based on the material support bar. And the Second Circuit majority remanded on that issue. Not before first affirming the denial of Convention Against Torture Deferral, though. It seems that it's not overly troubled by the agency's requirement that Mr. Sufiyan corroborate his credible testimony. But more importantly to the court, Mr. Sufiyan safely relocated for years and used a Sri Lankan passport to leave the country. That was enough to show that the agency wasn't reversibly wrong to deny cat protection. Plus, all this happened in 2009, there's no evidence that the army is still looking for him, and I believe the war is over. That last part is me. But now onto the material support thing. Whether Mr. Sufiyan provided material support to a terrorist organization is not actually before the Second Circuit, the court explains. And absolutely wild to me, there is no path to request a material support waiver from the literal immigration judge deciding the case. Instead, quote, the statute includes a process for seeking an exemption from USCIS to the material support bar, end quote. Make it make sense. And again, remember, the BIA relied only on the material support step to deny asylum and withholding of removal. That was error. Quote, the regulatory scheme as currently constituted requires the BIA to adjudicate the merits before or alongside adjudicating the material support question. Otherwise, the Department of Homeland Security's regulations and practices would effectively nullify the framework Congress established. The BIA already reached the same conclusion in matter of MHZ, end quote. Let's talk that one out with the Second Circuit. Explains the court, the USCIS waiver quote process serves as a relief valve, mitigating the otherwise harsh consequences of the inflexible material support bar, end quote. All important adjectives. To the Second Circuit, IJs and the BIA decide whether the bar applies in cases like this, based on a USCIS policy that should be unlawful. Quote, USCIS won't even consider an application for an exemption unless and until the BIA has determined that the applicant is otherwise eligible for the relief from removal and has issued a final order of removal based on the material support bar, end quote. This fact is well known to the BIA. Footnote 5 of matter of MHZ explains the Second Circuit. So with the BIA skipping the step where it determines whether Mr. Sufiyan qualifies for relief but for the bar, it has effectively precluded him from this very important safety valve. Quote, if the operation of a different statute depends on a finding of fact or a conclusion of law from the BIA, then it's up to the BIA to devise administrative procedures that will assure that it performs its duty, end quote. The BIA and DHS cannot act together to, quote, thwart the congressional scheme through their regulatory apparatus, end quote. You know I'll be remembering that. The majority tangles with the dissent for a bit and explains that all of this is consistent with the BIA's 2016 decision in matter of MHC, and that the BIA pretty much said the same thing that the Second Circuit is saying now. Quote, this rule is not a new or controversial one, end quote. And the BIA has done this very thing at least one time. Notes Human Right First in its amicus brief, citing an unpublished BIA remand from 2022. So this is getting remanded too. Continuing on though briefly, it is not the case that the agency must decide that Mr. Sufiyan provided support under duress. It would make a whole lot of sense if the statute and regulations required such a finding, but that's just me, and more importantly, the statute doesn't require the BIA to make that finding, explains the court. Nor is a duress finding technically required to get a waiver anyway. I bet it's essentially required in practice, though. Bet you a lot of money. As I mentioned, Judge Sullivan dissented on the remand stuff. But as such, congratulations Visuvanathan Rudrakumaran for petitioner. I've got a bit more, but something I've had waiting in the wings for a while now. Former immigration judge David Kelch is a friend of the podcast. I mentioned his new venture a few months ago. By the way, you can find him at AMDG Law LLC on LinkedIn or in other socials. Well, before becoming an IJ, he was the trig terrorism guy at the asylum office in Arlington. In that office, he was the guy involved with deciding whether a regulatory listed trig exception applied, which I believe is just a fancy way of saying waiver. And when I talked to him about this a few months ago, he described for me just how difficult it can all be. Right off the bat, he believes there's a new DHS policy alert from about a year ago indicating that discretion should be limited in trig cases. So, just right out of the gate. But procedurally, once at USCIS, the system seems set up to deny to me. All trig issues go to a supervisor, which I conceive makes sense, and then it goes to an internal trig person, and then they bring it to headquarters, if they want. Line officers have to go to a supervisor. The supervisor will go to the trig guy like David. Then the local trig guy will either deny or send it to headquarters. Because the internal trig guy doesn't have authority to grant. They can deny, but not grant. At least when it's an exception to trig. That kind of incentivizes denials though, right? And now exceptionally so. Who would want to stick their neck out for someone deemed to have materially supported terrorism in this Washington, D.C.? And there's no paper trail, or there at least didn't used to be. The trig guy in headquarters aren't always writing things down. No formal procedures. You may never really know why they said no to your client. If you jump through all of that, and you get your exception, or I assume waiver, the Mr. Sufiyans of the world still need to move to reopen their final removal orders to succeed. That is, of course, if they're not already removed to the country of fear in the interim. What a process! And given that one regulatory listed exception is in fact support under duress, well, it's no surprise that Mr. Sufiyan was trying to get the BIA to make that finding. Anyway, some context for you all. And that is Sufiyan v. Bondi. All right, friends, 4 from the BIA to do this week, so let's get to it. Although the first is technically from the AAO, matter of Texperts Incorporated. This case is about fraud in H-1Bs, and I promised last week that I'd do it this week. H-1B season is upon us, after all, making this particularly timely. Not to mention Staffy's new H-1B-related sponsorship. The AAO thanks you, Staffy, official sponsor of the AAO and BIA, I hear. Many people are saying it. Some of the best people. The AAO is the Administrative Appeals Office of USCIS. The AAO decides direct appeals of USCIS things, which the BIA can also do in limited circumstances, so that's confusing. And again, BIA case law decisions do bind the AAO, I believe, but not necessarily vice versa. The AAO doesn't publish decisions often, but when they do, I'll try to do them. Here's this. Texperts Incorporated is an information technology staffing company that seeks to temporarily employ the beneficiary as a database administrator. To do so, they filed an H-1B petition for the beneficiary. Congress set a cap of 65,000 initial H-1B visas or initial grants of H-1B status per fiscal year. Big tech companies gobble them all up. But you can't even potentially apply for them unless you're selected in the annual lottery, which, with so many people applying and with big tech gobbling it all up, can be hard to do. Lottery-exempt H-1Bs are easier to get selected for, by the way, but those are for non-citizens with master's or higher education degrees from U.S. institutions. This case is not such a case. With the lottery being so competitive, you can't submit multiple registrations for the same individual, to try to game the system. Nor can petitioning companies work together to try to increase the chances that a single non-citizen will be selected, and they must attest that they didn't. That's a newer rule, I believe. Here it looks like another company also petitioned for the beneficiary. As such, and although the beneficiary was selected in the lottery, USCIS sought to revoke it, noting fraud or material misrepresentation as the reason. Faced with a notice of intent to deny, alleging fraud, a serious thing, the petitioning company wanted no part of it, and so withdrew the petition for the beneficiary. Looks like the 2 different companies submitted the H-1B petition from the same IP address and everything, and IRS records show common ownership and other stuff. Not great. But despite the petition being withdrawn, USCIS made a fraud or willful misrepresentation finding against Texperts anyway, which will surely have a significant consequence going forward. Texperts appealed and the AAO dismissed the appeal here. USCIS can make a fraud finding even when a petitioner withdraws an H-1B petition. First off, the AAO explains it does have jurisdiction over this. While the regulation holds that you can't appeal a withdrawn application or petition, you can always appeal a fraud finding, even if it's related to the withdrawn application or petition. Other adverse actions, too, that will affect a petitioner or beneficiary going forward. Now, in 1976, the BIA held that a request for a withdrawal precludes USCIS from entering a decision on the merits of the benefit request. It's a matter of syndrome. The AAO, and surely new BIA doesn't love that, and so has now distinguished or clarified, whatever you want to call it. Reviewing the current regs, the AAO believes that actually, quote, the best interpretation of the regulations should allow USCIS to recognize a withdrawal while making further findings of fact relevant to future benefit requests, including fraud or willful misrepresentation of material fact, end quote. Have you ever had this situation with, say, a naturalization application and so withdrawn it? Tread carefully going forward, attorneys. Quote, considering the statute and DHS regulations as a whole, it would severely undermine the integrity of United States immigration laws to permit a party to evade the immigration consequences of fraud or willful misrepresentation by simply withdrawing the benefit request once those consequences were imminent, end quote. Now, this doesn't apply where a withdrawal is voluntary and timely. What is that? Subject to debate. But, quote, a retraction that is made in response to the actual or imminent exposure of the fraud is not timely, end quote. And that's what's happening here to the AAO. Turning then to whether fraud occurred. Well, first, the AAO reaffirms strong old precedent. Quote, Given the serious consequences inherent to fraud and misrepresentation, we are expected to closely scrutinize the factual basis for any possible finding." End quote. A good quote to use before the BIA, too. Fraud or willful misrep can be oral or written, explains the AAO, and it must be willful, an important element. Fraud, however, requires more culpable elements too, but practically speaking, it's kind of irrelevant because willful misrepresentation tanks an application too, and it requires a lesser showing. Anyway, and wouldn't you know it, I was a bit too hard on the AAO at the top. They actually don't think fraud or willful misrep was sufficiently shown here. Or that is to say, the AAO doesn't believe that the USCIS field office applied the fraud or willful misrep elements or made the required findings, particularly considering how serious a fraud or willful misrep finding is. Reading between the lines, if I had to guess, the AAO isn't convinced that a sufficient willfulness finding occurred. And importantly, quote, "If the director intended to reach the question of fraud, the decision should have included a discussion of the additional elements, including the petitioner's intent to deceive." End quote. By the way, citing to 8 CFR section 103.2b16I, USCIS does note that this fraud finding still can be rebutted in a future benefit request should the company or individual on the other side of it have the ability and desire. Also, the AAO notes in a footnote that there's quite a few ways to prove H-1B collusion, so watch out. Lots of nuggets in this one, and it's important to flag for many reasons that I hope I've hit for you all. So flag I did. And that is a matter of Texperts Incorporated. You didn't go to law school to enter data. I know I didn't. Yet here you are, H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Next up, matter of Pinzon Rozo, published by the BIA. This case is about continuances and special immigrant juvenile visas. I don't really practice in SIJ world, but I know about it, and I know that this has got a lot who do practice in that world quite upset, for reasons that are understandable. Before I begin, as an appeal of an IJ's grant of a continuance, this must be yet another DHS interlocutory appeal granted by the BIA, right? But unless I missed it, the BIA didn't add that footnote this time about how it rarely grants interlocutory appeals, but that this issue is so important, blah, blah, blah. Did someone at the BIA hear my comments last week? I see you, staff attorneys. I see you all. The BIA is very concerned these days with completing cases expeditiously. The problem is that there are just so many overlapping areas in immigration world, and IJs actually lack authority to decide many things. They can, of course, decide the very important thing of removing someone from the United States. But restated, the system is set up in a way that, if IJs act quickly and don't wait for other things to play out, more people will be removed than if the IJ permits a continuance to permit collateral things to be resolved. That's a systemic problem, in large part. Query why it's such a bad thing to wait for legitimate claims to play out before other tribunals, but that is not the point of this decision. SIJ is such a process. Mr. Pinzon Rozo is from Colombia, overstayed his tourist visa at about 13 years old, and filed an SIJ petition when he was still a child under immigration law in May of 2025. DHS initiated proceedings a few months later. Now, a state court must have determined that Mr. Pinzon Rozo was the victim of abuse, neglect, abandonment, or similar mistreatment, because USCIS then granted his SIJ visa petition in November 2025. No small thing. A state court and federal tribunal have both now all but concluded that Mr. Pinzon Rozo should get to stay in America and that he has a path to a green card due to things that happened to him as a young child. The only problem he now faces is one of bureaucracy. Problem 1. Congress has limited the amount of SIJ visas that can be issued, I believe, and that category is very oversubscribed. Currently, the Visa Bulletin lists July 15, 2021 as the current priority date. Restated, SIJ visas are backlogged nearly 5 years, meaning that Mr. Pinzon Rozo has well over 4 years to go before his May 2025 filing can benefit from the November 2025 approval. Problem 2. He entered the U.S. immigration system at a time where those in charge believe it vitally important to deport as many people as possible because that's what they believe America stands for. That's more a problem of politics. Mr. Pinzon Rozo is in removal proceedings, and so he moved for administrative closure. This does seem to be precisely the type of situation for which DOJ promulgated and initiated new administrative closure regulations. But this case isn't actually about administrative closure because the IJ denied it. Instead, the IJ did continue proceedings to February 2027 to see what would happen with the priority dates. Even that was too much for DHS, which appealed, and the BIA, which has now sustained that appeal. In determining whether good cause exists for a continuance based on the pendency of a collateral matter, an immigration judge, quote, must focus principally on 2 factors. 1, the likelihood that the non-citizen will receive the collateral relief, and 2, whether the relief will materially affect the outcome of the removal proceedings, end quote. Both of those completely support the respondent here. But the BIA explains that IJs should also focus on other factors, such as a non-citizen's reasonable diligence, DHS's position, the procedural history of a case, and the length of the requested continuance. All relying on Attorney General Sessions' matter of LABR decision, which, if you recall, involved egregious cases that are in no way similar to Mr. Pinzon Rozo. Excellent example of the agency using bad facts to make bad law and relying on it 8 years later. Although, to be fair to the BIA, which I always am, they also later quote a 1982 BIA decision regarding delay in approved visa petitions. Quote, the 2 primary factors are not dispositive when there are relevant secondary factors that weigh against continuing the proceedings, end quote. Honestly, it pretty much just comes down to the 4-year wait to the BIA. Plus, it explains priority dates can retrogress, meaning it might be even a longer wait. Could be shorter too, of course. But, quote, the amount of time the respondent would have to wait for a visa number is highly uncertain and potentially lengthy, end quote. Having made up its mind, the BIA belt and suspenders itself, explaining that it also doesn't believe that Mr. Pinzon Rozo established reasonable diligence. Why, it asks, didn't he take the initiative to file the SIJ petition at 13 years old? Or 14 when he was abandoned? Or at any other periods during his teenage child years? Tell you what, I'd hate for the BIA to be judging what I did or didn't do at that age. They must have been better or more diligent teenagers than me, because otherwise I don't really get it. Finally, explains the BIA, DHS's opposition is quite important. It, after all, has a, quote, interest in the prompt resolution of these proceedings, end quote, which is an important consideration for IJs too, the BIA explains. And no mention here either, unless I missed it, of the regulations and case law that explain that an IJ has significant discretion to control his or her own docket. Here, Mr. Pinzon Rozo isn't eligible for anything else, so a removal order is tantalizingly close, all but explains the BIA. So why not reach out and take it? Stating it has balanced everything, the BIA remanded for further proceedings in what very well might be a removal order very soon. And look, I'll concede that removal proceedings are in need of great reform, and 5 years to decide any case in any tribunal is too long, absent extraordinary circumstances. But immigration's different. Congress has created a Frankenstein with multiple parts working in parallel and sometimes at odds with one another, involving multiple federal and state agencies and systemic delays that are often not the fault of the non-citizen. If, as the BIA is doing, we simply throw up our hands and target efficiency over everything else, then what we're really doing is prioritizing removal, and in many cases ignoring injustice. There are also often serious due process problems. To paraphrase one recent circuit decision, just because there is a process doesn't make that process constitutionally sufficient. Congress is certainly to blame here, but I believe the agency equally guilty or even more so, because they know exactly where the flaws lie, and they seem to be issuing decisions intended to exploit them that will permit more removals. The BIA didn't write the laws, but they also don't have to craft a system that uses those laws to maximize cruelty, which is what seems to be happening more and more each week with these decisions, putting otherwise concerned IJs in a near impossible position too, in one podcaster's not-so-humble opinion. And that is matter of Pinzon, Rozo. Moving on to matter of ZNL, published by the BIA this week. It's a short case about bond, overturning an immigration judge's grant. A $7,500 bond, too. Not so small to many people. And, quote, immigration judges have broad discretion in deciding what factors to consider in determining whether a non-citizen warrants release from detention and, if so, what amount of bond is appropriate, end quote. But here's the kicker. The BIA says that it reviews that determination de novo. So how broad is that discretion really? Not very at all, if the last 14 or 15 months of precedential BIA decisions and mass firings are any indication. Here in one page, the BIA explains that it believes Mr. ZNL such a flight risk that he shouldn't get any bond at all. Quote, the record in this case includes inconsistent evidence regarding whether the respondent has a fixed address in the United States, end quote. The BIA relied on similar rationale last year in matter of Akhmedov, cites the BIA, and well, that's now precedent. Plus, the I-213 in this case claims that Mr. ZNL was apprehended at a business that was illegally growing marijuana in Oklahoma, and that Mr. ZNL lived there too. Not only that, the asylum application that Mr. ZNL filed with USCIS lists a California address. No mention whatsoever about how long between his apprehension in Oklahoma and the filing of that asylum application, which I would think kind of important, but then again, even if there was a significant gap, I suspect the BIA would then hold against Mr. ZNL his failure to update his address with USCIS. Mr. ZNL has a sponsor who it appears submitted a sworn affidavit. That alone is important evidence. It's an affidavit. And in that affidavit, the individual swears that he's Mr. ZNL's cousin and, I suppose, will support him and ensure that he shows up to court. Well, Mr. ZNL didn't submit proof of the cousin relationship, says the BIA. What is evidence of a cousin relationship, by the way? Birth certificates for both individuals from China with certified translations showing that they have the same parents from detention? Deesh. Also, I'm not quite sure why that's material. Can't a friend or non-blood relative be a sponsor? How would a respondent establish a friendship other than through affidavit? I don't know. Seems like the BIA just doesn't like that he was caught at a marijuana growing place, but doesn't want to come out and really rely on it. Suffice it to say that I remain unconvinced. But also, it does not matter what I think. Mr. ZNL's bond has been revoked. And that is matter of ZNL. The BIA got me too on a Friday, as it got all of us with matter of Medina, Madrid. If you thought we were done with the BIA this week after that last decision, you are wrong. We are never done. Ever. It never ends. They're issuing a decision right now, as we speak, as you think. Did you just think about something? Congratulations. The BIA just issued a decision adverse to non-citizens. This case is about administrative closure. The BIA has ruled in a pro se case that an immigration judge shouldn't do it to await USCIS's adjudication of a Form I-601A waiver, despite the regulation literally requiring administrative closure or termination for USCIS to approve an I-601A waiver. And of course, citing itself from last year where it did the same thing, the BIA states, quote, although we do not usually entertain interlocutory appeals, we deem it appropriate to do so here, end quote. Ms. Medina Madrid is from Mexico and has been in removal proceedings since 2004, a long time. And she filed for non-LPR cancellation of removal in 2007, meaning she's been here a really long time. DHS itself moved to administrative close the case in 2012 or 2013, where the case remained closed for 6 years. At that point, Ms. Medina Madrid married a U.S. citizen who filed a Form I-130 petition for her in 2019. For reasons that are unexplained and that don't make sense, that petition was not approved until 5 years later, 2024. Shortly after that, this new administration came into power, and DHS moved to recalendar as it did in so many cases. Ms. Medina Madrid opposed, arguing that she has recently filed an I-824 petition so she can then file an I-601A application and that I-824 is pending. Recognizing that Ms. Medina is screwed if the IJ recalendars proceedings, the IJ did not do so. DHS hates that and so appealed. And the BIA sustained this not so unusual interlocutory appeal. Let's just step back. We have no reason to believe that Ms. Medina was at fault for the 5-year delay in deciding her I-130 petition. And as we all know, she couldn't file the I-601A until it was approved. And it seems like she was pretty diligent in doing so. And of course, there's no mention of a criminal record. Nevertheless, the BIA is ordering IJs to prioritize the removal of such people. On its way to doing so, the BIA provides an extraordinary footnote that literally is positing out loud whether the Biden-era regulations for administrative closure are constitutional, the regulations that govern it, the BIA, citing itself from a couple of weeks ago for that proposition. Incredible stuff. And that nearly unconstrained animus certainly explains some of these recent decisions against administrative closure. BIA explains that whether to recalendar is the totality of the circumstances analysis that is also governed by the regulation that it despises, but that, again citing to its recent self, quote, the primary consideration in determining whether recalendaring is appropriate is whether there are persuasive reasons for a case to proceed and to be resolved on the merit, end quote. Here reasons the BIA is just going to take too long for USCIS to decide the 601A. So, it seems, because USCIS doesn't have enough resources, or isn't allocating the resources it currently has, notwithstanding the massive recent fee hike, to speed up 601A adjudication, Ms. Medina is at risk of physical removal. Similarly, the extraordinary USCIS delay in deciding that I-130 petition is cutting against her. Also explains the BIA, this case has been administratively closed for a long time, and that cuts against the denial of recalendering. Also, recall Ms. Medina doesn't actually have an I-601A filed yet, notes the BIA, and surely distinguishable from your case. She had to file an I-824, because in this silly system, if you check the adjustment of status box in the I-130 petition instead of consular processing, you can't start an I-601A process until, for a new I-824 application, USCIS sends the I-130 to the NBC, and that can take like a year. It's absurd, but it happened here, and so Ms. Medina couldn't file the I-601A right away. She has to go through this expensive, time-consuming, and pro forma process to get the I-130 to the NBC first. That cuts against her on recalendering too, explains the BIA. Ultimate I-601A relief is too speculative for the BIA given that she doesn't even have an application filed yet, and so couldn't submit that application for IJ review. Something you can, though, in your case. That said, the BIA notes that the 28-month estimated processing time for I-601As is long. And the BIA throws a lot of shade on I-601As later in the decision. I bet it doesn't like the Obama regulations for 601As either. Unconstitutional? Despite all of that discussion, remember folks, Ms. Medina doesn't actually have a 601A filed here. There might be a way to distinguish your case. But as such, quote, under these circumstances, further administrative closure exceeds all reasonable interpretations of a temporary period, end quote. On the facts of this case, the BIA sees this as effectively a, quote, amnesty, allowing an otherwise removable non-citizen to live indefinitely in the United States under a legally fictitious status, end quote. And so, quote, considering the strong public interest in the finality of immigration proceedings, the BIA deems it appropriate to recalendar these proceedings, end quote. How about that? And that is the matter of Medina, Madrid. Continuing on with Maldonado Ruiz v. Bondi, published by the First Circuit on March 10th, 2026. This case is about past persecution and nexus. Miss Maldonado Ruiz is from Honduras, and entered the United States without inspection or admission in 2012 near Hidalgo, Texas. She applied for asylum and related relief and protection in immigration court. She testified that her father, who she didn't meet until she was 7, was a drunk and was quite violent to her, her sister, and their mother. At 9, she witnessed a neighbor murder her brother-in-law when the brother-in-law confronted the neighbor. The family filed a complaint with police, but no arrest was made. Also, Ms. Maldonado Ruiz is bisexual and began a relationship with a woman in Honduras at the age of 22. People in the community called her and her partner a derogatory term, maramacha. They never harmed or threatened them, though. Her house was burglarized in 2009, and she witnessed another murder 2 years later. And in 2011, a man followed her and said very cruel things to her, and Ms. Maldonado thinks it's because of her sexual orientation. And she received a threatening text message. As described, it seems like a not great place to live. Ms. Maldonado married a man in 2014 in America, and they have a child together. She would continue to be in her marriage to him if she was removed to Honduras. She suffers from PTSD and receives therapy. And in 2019, she was arrested, quote, after she allegedly struck her husband 3 times with a baseball bat, end quote, although those charges were dismissed. Fun little footnote, that. An immigration judge denied for many reasons, and the BIA affirmed. And as Convention Against Torture Protection wasn't petitioned for review, it's asylum and withholding or bust. The First Circuit affirmed the agency on past persecution and nexus. Neither satisfied. Past persecution is substantial evidence review, notes the First Circuit, quoting the Supreme Court's Arias-Arena decision from just last week, which itself affirmed a First Circuit decision. First sight of that. Quote, persecution transcends unpleasantness, harassment, and basic suffering, and even credible threats must be so menacing as to cause significant actual suffering or harm, end quote. None of the facts that happened here rise to the level of past persecution, explains the First Circuit, and is in fact less than that found lacking in other First Circuit decisions. The First Circuit believes that the IJ and the BIA did in fact consider all harms cumulatively, including the resulting mental health stuff. Likely a legal argument though, that one. Applying substantial evidence review, the court also affirmed the no nexus finding, at least as relates to past persecution. Ms. Maldonado Ruiz focused heavily on that unknown man's threats, but apparently, quote, no reference was made at all towards her sexuality or her female partner, and her subjective belief is insufficient to establish nexus, end quote. That her sexual orientation was known to the community probably doesn't cut it, and certainly doesn't compel a finding contrary to that made by the agency, explains the court. Turning then to whether Ms. Maldonado Ruiz had a well-founded fear of future persecution, well, there were probably multiple reasons for the First Circuit, but here, the court focused on the lack of showing that the Honduran government is unable or unwilling to protect her. Ms. Maldonado Ruiz argued that the failure of police to do meaningful things after her brother-in-law's murder in the 1990s and the home burglary in 2009 so established that element. But the police took complaints and reports, and, quote, dissatisfaction that the complaints did not result in arrests or convictions, end quote, does not suffice. This is particularly so, quote, where local authorities responded immediately to each incident, end quote. Other reasons, too, explains the First Circuit, and the country condition evidence didn't independently establish a claim or show why the agency was super wrong. And for all of those reasons, the First Circuit denied the petition for review. And that is Maldonado Ruiz v. Bondi. Next is Alonso Juarez v. Bondi, published by the 8th Circuit on March 12, 2026. Quote, with nothing exceptional or extremely unusual about it, we deny the petition for review, end quote. That's how it kicks off. All right. Mr. Alonso Juarez is from Mexico. Seems like a good guy. Has lived here without authorization for a long time. Fell off a roof and got serious injuries. Ended up in removal proceedings. He was denied a continuance to get more evidence, and he and his wife testified in support of his non-LPR cancellation of removal application. Quote, both explained that deportation would cause hardship for their children, mainly because of the lower standard of living and poor educational prospects in Mexico. Each also thought work would be harder to find there, end quote. The immigration judge denied, the BIA affirmed, and so did the 8th Circuit. First, the court saw no reversible error in the continuance denial. He wanted more time to get evidence of the severity of his medical injuries post-roof fall, but the record already had significant evidence to the Eighth Circuit, and the evidence he was waiting on wouldn't meaningfully move the needle to the court. Plus, he never submitted it to the BIA in a motion to remand or to the Eighth Circuit to show what it was, explains the court. Under the merits then, and actually, quote, reviewing a hardship determination is new to us, end quote. Seems like the Eighth Circuit was in the unreviewable camp pre-Wilkinson, but now it must review. So the panel first needs to explain what that standard of review is. And unfortunately, quote, we know from Wilkinson that factually intensive mixed questions get a more deferential standard of review, end quote. But which one? Asks the Eighth Circuit. Well, like the other circuits before it, the Eighth Circuit sees this as a fact-intensive, mixed question of law and fact, meaning to it, substantial evidence review is the proper standard. A conclusion probably also supported by the Supreme Court's decision last week. It's the Second Circuit, by the way, that adopted clear error review instead, cites the Eighth Circuit. Such an unimportant circuit split that I'm not going to gong it every time one of these circuits does this decision, which is going to happen this year. The Eighth Circuit does explain that clear error can't work, though, because that's a review, quote, for findings made by a court, not an agency, even when the subject is immigration, end quote, an emphasis by the court. Oh, the disrespect. Having decided the standard of review, the Eighth Circuit affirmed the agency in one paragraph. In addition to other issues, I imagine, the Eighth Circuit notes that a medical report indicated that Mr. Alonso Juarez could return to work without restriction, and that additionally, they had family in Mexico to help with their transition back into that country. So the court denied the petition for review. And that is Alonso Juarez v. Bondi.
Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. The skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.pen-and-swordkc.org or at the special links in the show notes. Use special code ImmigrationReview26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. Long case to end a long episode. Dekovic et al. V. Rubio et al., published by the 10th Circuit on March 10th, 2026. This case is about citizenship, visas, and aging out children. Never straightforward issues, any of those, and this decision proves it. The legal question is this, quote,
whether a child of a lawful permanent resident who was deemed by statute to be a minor child until the very day his parent naturalized still qualified as a minor on that day, or whether instead his parent's naturalization transformed him on the spot from a minor into an adult." End quote. Agreeing with 3 circuits already, the 10th Circuit holds that it's the former. Good for non-citizens. Here's how the 10th Circuit gets there. First, it's important because it implicates visa categories. Minor children of U.S. citizens don't have visa limits on immigration, but the other categories do, including minor children of LPRs, unmarried adult children of U.S. citizens, etc. And the wait time for the other categories can be very, very long, as we all know. Also, because of backlog issues, there is an age-out problem. Children can, for example, be included on their parents' visa application, but if the wait time is like 10 years, they might age out during that wait time and get screwed. That seemed pretty unfair to Congress, which in 2002, quote, "with unanimous bipartisan support, enacted the Child Status Protection Act, or CSPA," end quote. Can you imagine such a time? The CSPA protects against aging out in several ways. First, for the children of U.S. citizens who are younger than 21 when the I-130 is filed, the CSPA provides that the age of the non-citizen child is made using the age on the date which the petition is filed. That means where the CSPA applies, and maybe with exceptions because I don't want to be sued, the child's age freezes on the date the petition is filed and throughout the visa process, no matter how much time passes. Such children of U.S. citizens. With children of LPRs, it's more complicated, and that's the issue here. That's the F2A visa category. Remember, they're subject to a backlog, meaning that even when the petitions are approved, applicants need to wait for more years. The CSPA forgives the time that it takes for the Department of State or USCIS to approve the petition. 6 to 24 months these days, I'd say. But the time waiting in queue for an actual visa to become available due to the backlog after the approval of the I-130, that's counted against the child's age. So that very much could age out a child because sometimes the wait is many years. Yet there's another exception, quote, "as soon as a visa becomes available, the beneficiary's statutory age is frozen at that point in time, meaning that no delay in the subsequent visa approval process will be counted against the beneficiary," end quote, unless the beneficiary fails to seek a visa within the next year. Are you following? Good case to review when you get a CSPA issue. You kind of always have to review the law when you get a CSPA issue. Quote, "thus, under the CSPA, the only time that counts against an F2A beneficiary is the time in which she is waiting in a visa queue, i.e. waiting for her priority date to become current in the Department of State's visa bulletin," end quote. One more thing, which is the direct issue here. What happens when the sponsoring lawful permanent resident parent naturalizes to U.S. citizenship during the visa process? That then transforms the F2A or F2B petition into an immediate relative or an F1, depending on if the beneficiary is a child or not. And so, if the beneficiary is already an adult, that's an F2B transforming into an F1. And the statute actually permits the beneficiary to elect not to have it transformed into the F1 if, say, the F2B category has less of a wait time. Nice bipartisan statute there. Thank you, Congress. Now, the real name of the game would be getting the F2A transformed into an immediate relative petition, because then there's no wait time. But that's only if the beneficiary is still a child under 21, of course. And that determination, quote, "shall be made using the age of the non-citizen on the date of the parent's naturalization," end quote. Which I guess is the actual biological age? Again, another note, Ira's got a really good CSPA chart in his book. Check it out. Narrowing down the issue in this case. Can beneficiaries choose not to get transformed from F2A into F1, just like F2Bs can so choose? That's very important to appellant Delia Decovic's son, Alejandro Ramirez. He was 20 years old when Ms. Decovic filed an I-130 petition for him. Because she was a lawful permanent resident, that makes it an F2A category for an immigrant visa. Took 2 years to approve, by which time Mr. Ramirez is of course 22 years old, but the CSPA freezes him at 20. And wouldn't you know it, the F2A visa category is current, so Mr. Ramirez could immigrate. except Miss Dekovic naturalized while Mr. Ramirez was trying to get that visa. The Department of State took the position that that transformed Mr. Ramirez into an F1, an adult son of a U.S. citizen. And that category was very much not current. 20-year-long wait because Mr. Ramirez is from Mexico. Wild. The day before, he could immediately immigrate, and the day after, 20-year wait. So the family sued in federal court, where they lost. But the 10th Circuit has reversed it. Secretary of State and the director of the NBC are the proper defendants, by the way, explains the 10th Circuit. And yes, the reclassification is a final agency action, explains the 10th Circuit, over many pages, thereby making it a proper focus of an APA lawsuit. A very important litigation holding and discussion for you federal litigators out there, and so I strongly recommend the read. It's final agency action, not least of which because, quote, the NBC's classification decisions would be effectively shielded from judicial review if they could not be reviewed when they occurred, but could instead only be reviewed after the beneficiary was finally able to receive a visa interview with a consular officer, an event that might not occur until decades later, end quote. Far too much power to the agency if it can play games and delay to avoid federal court review, so the 10th Circuit ain't gonna do it. On to the merits then, where it mostly comes down to the word age in the statute. Given this whole CSPA framework where all this is originating, it's not the biological age that we're looking at from when the parent naturalizes. It's the child's CSPA age. So I think my statement above was incorrect. Lots of statutory text reasons, not to mention the, quote, significant anomalies, end quote, that would result otherwise, including making a young man wait 20 years when he was literally about to be allowed to come to America. The statute, after all, wants to keep families together. Why would Congress want to punish people for naturalizing instead? Doesn't make sense. Nor does it make sense to afford adult F2B beneficiaries a benefit that minor F2A beneficiaries don't get. That is, the option of avoiding reclassification. Lots more to it, but this is already a lot. I know. I'm saying it. In so holding, the 10th Circuit agrees with the 2nd, 9th, and 1st Circuits. That final one from episode 282. That means no gong. Sorry, Mom. Lots more statutory interpretation reasons that I've glossed over as well, and there was some legislative history. And this nice quote too, to boot. Quote, while reliance on legislative purpose is sometimes criticized on the ground that Congress is a divided body that does not speak with a single voice or purpose, that critique does not apply here, end quote. Pretty good point. Remember, unanimous, bipartisan legislation. And the whole point was to keep families together and not punish aged-out children. Brain twister of a decision. Must have been a heck of a briefing. And so, congratulations, immigration attorney extraordinaire and litigation demon of the Western region, Mark Robert Barr, for appellants. You like that, Mark? Came up with that myself. And as Mark notes, the 10th Circuit did all of this without so much as mentioning the BIA's contrary precedential decision. The indignity. I'm offended for you, BIA. But I'm out of time. So that is Dekovic et al. V. Rubio et al.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Oh. Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.